Thank you. Hello, I'm Dr. Bronwyn Naylor. I'm the Acting Director of the Castan Centre, and I'd like to first of all acknowledge the people of the Kulin Nations on whose land we're gathered today, and to pay my respects to elders past and present. So welcome everyone. I'd like to welcome you tonight to an event on a really important topic where we were very happy to be asked by my law faculty colleague Dr. Kate Sear to co-host this event with her and Dr. Claire Spivakovsky from the Faculty of Arts and Dr. Adrian Carter from the Faculty of Medicine, Nursing and Health Sciences. There are, of course, challenging human rights issues in this area of mandatory medical treatment, and the Castan Centre is delighted to be able to help to present them in a public forum tonight. I should also say that if you're keen to tweet on events tonight, please use the hashtag ASA16. We look forward to following the Twitter feed. Thank you. So, without further ado, please welcome the facilitator of the event, Dr. Ian Freckleton, QC, who is a professorial fellow in law and psychiatry at the University of Melbourne and also adjunct professor of law and forensic medicine at Monash University. Thanks, Ian.
Thank you, Bronwyn, and welcome everyone. We hope that tonight is going to be a really stimulating discussion that reflects on coercion, the use of force against people to compel them to receive medical treatment. It happens a lot in all kinds of different contexts. Some of them one doesn't think of immediately. It happens in relation to people who are substance dependent, people who are intellectually disabled, people who are psychiatrically unwell, people who have brain injuries. Sometimes it's ordered by tribunals like VCAT in relation to people who are thought to have lost capacity to make decisions in their own best interests. Sometimes it happens from criminal courts in respect of people who have committed significant offences. Sometimes it happens from Supreme Courts in the exercise of what's quaintly and in an old-fashioned way called their parens patriae jurisdiction, to order people without capacity to have treatment, again, in their best interests. All of these impact in a profound and very practical way upon people's human rights to make their own decisions about their own bodies. There are really hard balances here. They involve not just the individuals concerned, but those who care about them and those who are affected by them. And so we're talking about the potential of harm to individuals who are the subject of mandated treatment, to those who are close to them, and to a whole range of people who could be adversely affected if the orders are made, or if the orders are perhaps not made. I'm trying to get ready for tonight. I found an article by George Smuckler called Compulsion and Coercion in Mental Health Care. And he started off in a very straightforward way, using that word. He said, compulsion in mental health care is a reasonably straightforward notion. I started wondering why we were here then. He said, the use of force, one hopes always governed by law, to make a person accept treatment that has been refused. The term coercion is usually taken to include compulsion, but includes a whole range of practices. It doesn't take us so far. Last night there was another gathering involving some 2,000 people at the Graham Clark Oration at the Convention Centre. And an address was given by Thomas Insel, who is the former director of the National Institute of Mental Health in the United States. And he gave an absolutely fascinating talk about different areas which are starting to converge in relation to treatment of mental health. He talked about genomics, and he talked about the use of technology, and about what we can learn from neurology. But one thing that struck me is that he talked about doing to people, doing with people, and doing for people. Doing to people is, of course, has that resonance of infliction of treatment where it may well not be wanted. Doing for people has that kind of patronising condescending, we know best and we're going to help you. But doing with people is perhaps another kind of concept which reduces, perhaps even eliminates the use of coercion, but tries to work with the idea of collaboration, facilitating people's recovery and enabling them to participate in a significant way in decision making. Perhaps that's the antithesis to coerced or mandated medical treatment. So we're going to think about coercion, what it means, when it's justified, when it's necessary, when it's helpful, and how it intersects with human rights, what the human rights are that are in play here, and what the balances are when it's justified to encroach upon human rights, because we do that all the time too. Human rights aren't just a thing that one respects and adheres to and that's the end of a conversation. It's all about balancing, isn't it? But the balancing exercise is changing as we think more deeply and more sensitively about some of these difficult issues. So enough from me for now. What we're going to do is hear from 4 people with really informed perspectives. They're just going to be asked to speak briefly to us, and then I'm going to try to facilitate a discussion involving our panellists, and then involving you as well, so that we can gain a better understanding of where the issues are and maybe where some of the solutions might lie. So let me tell you a little bit about the panellists. I'm not going to do it at length, because it's much better to just hear from them, but I want you to know who they are. The first one is Chris Ryan. He's a clinical associate professor at the University of Sydney. He's associated with the university's Centre for Values, Ethics and Law in Medicine. He's a psychiatrist, of course, by background, and he's written very extensively on a whole range of issues that are relevant to what we're meeting about today, particularly about the Convention on the Rights of Persons with Disabilities, about issues to do with capacity and decision making, and also about domestic squalor, but you can tell us about that later, Chris. The next speaker will be Bernadette McSherry. Bernadette is a professor at the University of Melbourne these days. She's a foundation director of the Melbourne Social Equity Institute, which is a vibrant organisation at Melbourne University. She's a professor of law at the law school there. She's also currently president of the Australian and New Zealand Association of Psychiatry, Psychology and Law, legal member of the Victorian Mental Health Tribunal, member of the Mental Health Law and Policy Institute at Simon Fraser University in Canada. She's a Research Council Federation Fellow, Fellow of the Academy of Social Sciences in Australia and of the Australian Academy of Law. She's written a whole string of books on people who are dangerous, managing fear, rethinking rights-based mental health care, coercive care. It's a range of issues which are very pertinent for what we're talking about tonight. Next is Eleanor Fritzer. Eleanor is a senior lawyer at Victoria Legal Aid in their mental health and disability law team. She advises people who are subjected to detention, supervision, compulsory treatment, substituted decision-making orders. Previously, she was a duty lawyer in the Assessment and Referral Court List, which is a therapeutic criminal court for persons who are accused of criminal offences and who have disabilities and or mental health issues. In 2015, Eleanor undertook a Churchill Fellowship exploring how better to protect human rights and the dignity of people with disabilities who've been detained on a compulsory basis. And her report, which I commend to you, was just recently launched and is available for your perusal. And last, and by no means least, is Kath Roper. Kath has a whole variety of qualifications in arts and education. She also holds a Master's in Social Health. She brings a different perspective and a very important one. She held one of 4 pioneering staff consumer consultant positions in mental health services in Victoria for the latter part of the 1990s. And she became the first consumer academic in Australia at the Centre for Psychiatric Nursing at the University of Melbourne. She's authorised us to say to you that she experienced involuntary detention on multiple occasions over quite a period of time, and that understandably researched or influenced both her research and her teaching interests. And so she'll bring those perspectives to bear on our conversation. So what I'm going to do is ask Chris, Bernadette, Eleanor and Kath to speak to us for 5 minutes each, and then we'll all talk. Thank you. First up then, Chris.
Hi. So what I thought I would do is, because basically I'm a clinician, and that's what I do. I see people. Pretty much that's what I do, really, just see people. So I thought, because Ian's given a great sort of overview, but it's probably still a little bit abstract at the moment, so I thought I'd just sort of fill that in with some actual things that happened. You know, that might just fill things out, not going to come to any conclusions or anything. I think probably the basic tension, there's a tension here, and the basic tension is that on the one hand, we all feel, we justifiably, that we should be the people that make the decisions about whether we have medical treatment or not. This is not the sort of thing that should be put off to doctors, that's the sort of thing that we should be making the treatments about. And I think we all feel that quite strongly, and you can imagine a world where that wasn't the case, and you wouldn't want to live in that world. So, for example, you get diagnosed with cancer, you go and see the oncologist tells you all about the treatments, and then she adds, oh, and also you're having them, and you go, well, actually, I don't know, we'll have them, and she, no, you actually are having them, and if you don't have them, I'm going to lock you up in hospital and give you the chemotherapy by injection. That is like weird. No one would want to live in that world, and that's why we very strongly feel that doctors shouldn't be allowed to do this. However, on the other side of the coin, there are some medical conditions that either temporarily or in some cases permanently take away a person's ability to make a decision about whether they want medical treatment or not. What sort of conditions am I talking about there? Well, the most straightforward one, obviously, is being unconscious. If I were to have a heart attack right at the moment and fall to the floor, then I wouldn't want a situation where you could only do CPR. Can some people do CPR here? Yes, good, okay, very good. Probably wouldn't be relevant otherwise. Where people could only do CPR after they'd asked me, right? That would be a terrible situation, you know. Do you want CPR, mate? Are you any sorry, I can't. No, that's no good. We've got to have a situation where we can go in and give CPR. And you don't have to be unconscious. There are other medical conditions which which do actually take away people's ability to work out whether they want treatment or not. Another one is delirium. If you remember the old movies, cowboy movies, very old now, probably I can see some people in the audience that can't remember these, but anyway, there were cowboy movies at one point, and what would happen is that the hero would get double pneumonia. And if you got double pneumonia, you'd be lying in the bed, and you'd be grey and sweating and whatever, and basically that person was delirious. And anyone who gets sick enough will get delirious. If these days pneumonia is relatively easily treated, you just give someone a drip and you put antibiotics in the drip and they get better. But imagine a situation where you got pneumonia and then you got delirious, and then I come with my antibiotics and say, here, would you like some antibiotics? And you say, I don't want antibiotics, whatever, you don't want those things. If you don't have the antibiotics, you're likely to die, but because of this delirium, it doesn't really seem like you can quite understand that. It doesn't seem like we should really be taking that refusal from this confused person as the sort of thing we should be following. And that happens in hospitals all the time, basically. People get delirious a lot and they are given treatment even though they haven't asked for it. But you don't have to be unconscious, you don't have to be delirious. You can also, for example, suffer a mental illness. So, imagine a situation where you or someone you love were to suffer from schizophrenia or bipolar disorder or a very severe depression. And imagine a situation where you were of the view, perhaps because you had schizophrenia, that there was a worldwide conspiracy run through the internet which was aimed at stopping your heart. And a doctor, and that's terrible because you're pretty much terrified all the time that you could be killed at any moment. In fact, anyone with a mobile phone could kill you. So it's a terribly distressing way to be. And a doctor comes up to you and says, well, look, we can give you some medication that will take that feeling away. But you, not unreasonably, given the circumstances, say, well, why would I want medication? Medication can't possibly interfere with the internet. And then you also notice that the doctor has a mobile phone. So you feel there's something fishy going on. You're not going to agree to have the medication in that circumstance. Again, it seems like there should be some mechanism in that circumstance where we could provide medication to that person, even though they're saying that they don't want it. And the reason we think that we should be able to do that is because even though they're saying they don't want it, they don't seem to either understand the information that we've given them, or that something's going on so they can't really weigh that information up to come to the sort of decision that they would, except for their illness. So, there are ways around that, and that's called mandated medical treatment. So, can human rights exist alongside mandated medical treatment? Yes, it can, but only in very limited circumstances and only if it's very carefully regulated. Thank you very much.
Bernadette is our second speaker.
Okay.
I think we might stop getting up so
Yes,
that no one falls down at the back here.
It is quite true.
Yes, it's about 20 metres down there.
Compulsory treatment does breach human rights. Why? Because we've been told by lawyers, by judges, and also by the United Nations Committee on the Convention on the Rights of Persons with Disabilities. There was a case here in Victoria decided a few years back by Justice Bell, and he said that compulsory treatment engages a number of charter rights. We in Victoria have a charter of rights and responsibilities. He said it engages liberty and security of the person, the right to privacy, the right to freedom of movement, the right to freedom from medical treatment without full, free and informed consent. The United Nations Committee has gone one step further, and it has told Australia, which has ratified this convention, that it should repeal all legislation that authorises medical intervention without free and informed consent of the persons with disabilities concerned. Under the convention, those with mental and intellectual impairments, that's the words used in Article 1, are covered. The committee has also said that Australia should ban the committal of individuals to detention in mental health facilities, or the imposition of compulsory treatment either in institutions or in the community by means of community treatment orders. So we have here a United Nations body that clearly says compulsory medical treatment breaches human rights, and any legislation that enables this should be repealed. So that's the extreme position that I think we have to face. So why is it that we still have legislation that enables compulsory treatment? Well, Justice Bell said despite compulsory treatment engaging, as he said, or limiting human rights, it could still be justified on the grounds of medical necessity and was subject to various safeguards. And I think that's probably Chris's position, that there are some extreme circumstances where compulsory treatment is justified. Brenda Hale, who's a justice in England, has talked about, again, this balancing act that Ian's referred to, and said that mental health laws perpetually struggle to balance protecting the public, obtaining access to the services people need, and safeguarding users' civil rights. So even though we know that compulsory treatment does breach a number of human Nevertheless, some people say that this can still be justified. Now, most of the focus to date in the academic writing has been on one paragraph of one aspect of health. And his view is that health is not simply a matter of lifestyle or access to healthcare, but is instead related to the inequality of economic and social conditions that affect us all. So I think we should be focusing much more on preventing ill health through lessening inequality and discrimination by focusing on the positive rights that states parties must comply with in this convention. Some of us in the criminal justice field are now talking about justice reinvestment, which means taking away resources from prisons, putting it into the community and working towards rehabilitation and reintegration. So why don't we use the positive rights in the convention to advocate for some form of reinvestment so that people don't reach the state of distress that needs compulsory treatment. So preventing compulsory treatment to me seems to be so much better an approach than having it as the sole focus.
Eleanor, you're next. I think there's almost no decision for you. If you try to get through here, it's just you'll be into the abyss.
So my essential take on this is whether or not you could design a law and write a law and enact a law that on the face of it would comply with the CRPD and would respect rights as dictated by CRPD and other human rights instruments. From my perspective as a practicing lawyer and what I see going into hospitals and institutions and facilities and other places where compulsory treatment is currently administered to people, my sense is that it will be impossible to have a regime that in practice would respect people's rights. So while written laws themselves potentially could be designed that will respect people's rights, they're such a small part of the way in which compulsory treatment is administered, in which those laws are applied. There are so many structural, practical, operational, attitudinal factors that impact on the way in which those laws work in practice that really undermine any positive human rights intention or safeguards that might be written into the face of legislation. And so, for instance, we've got, as many of you know, a Mental Health Act in Victoria that's been in place for a couple of years. There were many years of consultation and development that led up to this. And while there are many glaring holes, perhaps you could say, in our current Mental Health Act in terms of how it doesn't respect human rights. It allows people's treatment, people's decisions to be overridden where they have capacity. It allows things that would not be compatible with most people's reading the human rights compatible regime. Even the bits of the Act that are meant to be protective of human rights just don't occur as they're designed to by Parliament. So why is it that we can write a law that looks like it might comply with human rights and then it falls down in practice? There are a range of reasons why things don't work in practice. One barrier, particularly in our mental health laws, is that a lot of the decision making is done by clinicians and psychiatrists, and with no disrespect to Chris, obviously. We see, speaking as a lawyer going into these environments and dealing with people subject to these laws, we see a lot of these people empowered to make decisions under these laws, having just no understanding of what the requirements of the law actually state. They don't even know sometimes what decisions they're tasked with making. And it's a really unusual area of law and probably quite unique that you could have somebody with no legal training, no qualifications in law and human rights, empowered to make a decision that can detain a person or interfere with their bodily integrity by forcing treatment on them. And it's just perplexing that happens. Even really clear express requirements in our mental health laws that really clear on the face what you're meant to do just aren't complied with in practice, and we see that day in, day out. The more nuanced and complex the task is that the decision makers are required to go through, the more they're sort of balancing up what's least restrictive and give account to this factor and have regard to this, the less that's likely to occur in a meaningful way in practice as decision makers become more and more removed from what it is that they're doing these kind of decisions, they're very much, the majority of them, operating in a medical model where they're tasked with thinking about people's best interest, and they often have a very narrow understanding of what best interest might be. It's often a very clinical-based understanding. It's not a holistic understanding of what might be in a person's interests. And so it's not surprising that they don't approach that task in the way that, as lawyers, we would want someone to approach a decision-making task. So even when a clinician or doctor or decision-maker understands what's required of them by the law, unless they understand the intention behind those requirements and the significance of those protections and safeguards, they're less likely to give effect to them because they're not motivated to comply with them. They don't get why they're important. They're not going to go out of their way to comply with them. For instance, we have a requirement in our Mental Health Act that people are given access to information relevant to the hearing at least 48 hours before the hearing. And that might seem like this really arbitrary, meaningless requirement in the Act, but if you think about what that means for a person faced with a mental health tribunal hearing, tasked with determining is this treatment necessary and justified, if you're not getting access to the information you need until the moment of the hearing, or new information's coming out in the hearing, you don't have time to reflect on it and absorb it and plan your response, it really impacts on your ability to get a fair hearing. And we often see decision makers not appreciating the significance of what they're being tasked to do by Parliament. One of the major factors that I think really impacts on practical compliance with the requirements of the Act is lack of resources and staff resources and time constraints. So our Mental Health Act, like many of our compulsory treatment laws here, sets out in some places, some okay, ranging up to quite good processes for how you go about making decisions, what you have to do before you can override someone's wishes. But it takes time to do that. It takes time to give people information, to explain it, to let them sit with that information, to consult others who they can bounce ideas off. And where doctors, psychiatrists at least, typically seeing people maybe once a week when they're in detention, every few months when they're in the community, they don't have time to go through this process. They don't. They just shortcut to the end point of having the power to make the compulsory treatment decision, and having that power up their sleeve really impedes the intention of Parliament that there's a dialogue that occurs before compulsory treatment decisions are made. And I think it's practically impossible to think that anyone's capacity can be meaningfully assessed in that really limited window that psychiatrists have to interact with people in these situations. It's just such a narrow window, it can't happen meaningfully in practice, I don't think. And we can tell that that decisions that are made behind closed doors by clinicians in these environments aren't necessarily following what the law requires when we compare it to when you bring those kind of decisions into a more transparent forum. So like decisions in relation to ECT do come before the Mental Health Tribunal, all other treatment decisions other than neurosurgery made behind closed doors. When you bring that decision into a more public forum, you take the time to tease it out and to explore what information is being given, how is it working, we see a very different approach to decision making and to assessment of have we reached a point where we can actually conclude that this person doesn't have the capacity to make that decision. And more often than not, if you go through that process properly, people are able to be supported to make their own decisions if the time is taken to do that. And as Bernadette said, obviously the real structural barrier of all the funding being directed to the crisis end of the system, to the detention, the really restrictive end of the system means that the resources aren't there to create less restrictive alternatives in practice. So you can have a law, as most of our compulsory treatment laws say, where we'll do what's least restrictive in practice, and that sounds human rights compliant on its face, but in practice those less restrictive options aren't there for people. Community mental health services aren't always resourced to be able to visit people in their homes and do outreach support and take the time necessary to engage a person. And so in practice it falls over the less restrictive option that is practically available simply becomes compulsory treatment or treatment in detention. So as I said, my concern is that yes, you could potentially design a law that looks compliant, but there are just so many structural barriers and attitudinal barriers that mean it's just not going to work in practice that I can see.
perspective.
So I've possibly done something a bit ridiculous, which is just at the tail end of a cold, thinking for the first time, because I tend to over-prepare, why don't I do this with almost no notes? And certainly not something written that'll make me feel really confident the way that I normally do. So if I suddenly start to dry up. So what I'm going to say is, I suppose what I want to say is, I feel like, having been someone who has been hospitalised and has, who knows what it's like to be mad and to have been mad, I guess my starting point is what I would love to see in our communities and in our world, possibly in the Western world, I don't know, but a much greater tolerance for and embracing of different ways people are in the world, different ways that people make meaning, different ways that people behave and act. And I guess I wish that we had attitudes towards people that are around being curious, not around fear, around extending towards people and the space that we find them in, rather than judging, I suppose, and judging whether or not a person is going to do something that's unexpected. So that's kind of where I want to come from. Because I don't think this is a health issue. It's never felt like a health issue for me. And I hesitate to say that. So I don't want that to be kind of like a pronouncement that for no one else is it a health issue. But certainly for me, and the experiences that I went through, the madness that I know, and that I do find some meaning from, even though I also find some, terror and so on associated with it. Those things sort of are precious too. And I also have to say that in speaking, I might be a bit associative, and I'm not going to apologise for that, because one aspect of madness is that it isn't necessarily sequential and logical, and I guess part of me also wants to make a bid for us expanding our ideas about how to be and how to speak on a panel like this. And I'm going to make a big bid that says I'm not necessarily able to do that, logical kind of argument thing. So I'm going to be associative. And for people who don't like that, well, that's okay. You can sit there and not really like that and sort of think, but I don't know where she's going, and she might be going crazy. And so you can sit with a little bit of discomfort there. And, oh my God, she's going to go overtime. That kind of uncomfortableness. I don't think human rights can go. How's the question phrased? I think it's there's no way that you can have treatment occurring forcibly, particularly if I've just said I don't think this is for me. I don't think this is a health issue. This is not life-saving treatment. The stuff that I was given was not life-saving treatment. It is so ineffective in terms of the statistics for someone who's been through the diagnoses that I've had, that it's not life-saving. It has a whole lot of other consequences, and I don't think it's right at all that I should be physically, because when you say no to something, it's different from health in a way, because the treatment I was saying no to, I didn't want. I'm ambulant. I'm not unconscious. I'm not in a bed even. I'm not sickly. I'm actually really healthy physically. And so to give me the treatment that I don't want means doing it violently. Okay, so it means holding me down. It means taking my clothes off, my lower, and it means being injected against my will. All of it against my will. And I still feel like those things are not thought of properly. Those things are not thought of. We get caught in this trap of wanting to justify things. My students want to say, but I know the students that I teach want to say we had to do this, and afterwards the person was really grateful. But I want to say that's not good enough. We can't stop there. We can't say this treatment was necessary. That paternalism may well be justified. On the one hand, we might lose someone from this planet if we don't act, if we don't do paternalistic things. I have nothing against paternalism kind of per se. However, what I want us to see, what I want us to count is that damage that we do. If it's violence, we cannot say, as a community, we cannot say that was not violent. What's been done to me, it can't be wiped away. It has to be counted, it has to be noticed, it has to be regretted. To not do so is such an ethical violation. It's a human rights violation. I don't know, I kind of don't understand that as much, but it's such an ethical violation.
Brava,
To
Cat,
not
brava,
count that.
brava.
Thank you. That might do me.
The violence that is inherent in coerced treatment and experienced as such by so many people. And we've talked about tolerance and risk. I'd like to start with the issue of risk, because so many of the justifications for imposing involuntary treatment focus around risk to the patient, the person with a mental illness, and what's said to be risk to others. And there are awful things that happen from time to time. What about this issue of risk? To what extent does risk justify imposition of medical treatment that is unwanted? I'm going to start with you, Bernadette, because you've written so much about a risk society. Where does that factor into decision making in this context?
Well, certainly if you look at the legislation, it is the key factor across many countries.
Mm.
And I think, well, Chris probably has some things to say about this, but it's kind of assumed that there is a risk of harm either to self or others without a very strong evidence base. So I think we need to question that. And throughout, if you look at historical cycles and so on, it's always been certain outgroups in society who are feared and therefore are detained or contained in some way. So I think we do have to challenge the presumptions about risk. Now, it may be that there is some evidence for a small subgroup of some people who have been diagnosed with mental health issues that do, go on and perhaps because of command hallucinations attack someone, whatever. But it's a tiny, tiny, tiny percentage, and I don't think we should be building an entire scheme around that tiny, tiny percentage. And particularly if you look at it in terms of the Convention on the Rights of Persons with Disabilities, it's really questioning that presumption and the idea of detaining people simply because of a diagnosis. If we're going to detain people, why aren't we detaining young men with alcohol, substance abuse issues all the time? So I kind of query the statistics behind it, but I think Chris has done more sort of research.
Well, let's go to you, Chris. You've had to deal with any number of cases where homicides have been committed. The incidence of suicide amongst people with psychotic illnesses is frighteningly high. Where do these realities factor into mandated medical treatment?
Well, risk actually should play no role at all. There's really no reason at all to consider risk. And the reasons for that are just simple maths. Yes, those things happen, but they hardly ever happen. Even suicide hardly ever happens. Even though it is certainly the case that somebody in a psychiatric crisis is at much higher risk of eventual suicide than people in the general community, it's fortunately the case that the risk in the general community of suicide is very low. And so even if you multiply that by up to 30 times, it's still very low.
But what's the percentage of lifetime risk of a person with schizophrenia committing suicide?
It's about 10%.
Medication.
it's the medication that you put
That
on
can be,
us.
that can be part of the mix,
Yes.
can't it? Okay.
So, do you factor that in?
Yes, you should definitely factor that.
Yeah, because
But
that
you
means
shouldn't
people
factor
want to
in
die.
risk. The other reason you shouldn't factor in risk is
Torture.
that there's no way of looking at the person in front of you and working out whether they're in a particularly high risk group. So you know they're in a particularly high risk group because if I'm seeing them, they're in some sort of psychiatric crisis. That's where I work. So they are in a particularly high risk group, but I can't work out whether this person that I'm seeing is any more high risk than this person. So when I'm assessing people with respect to the Mental Health Act, for example, I have no consideration for risk at all. It just doesn't enter my head. It is much more about what the person's experience is right now. In the example I gave, the gentleman who, which is a real example, the gentleman who was terrified that there was an internet conspiracy that would lead to his heart stopping and could be operated by a mobile phone. There's no reason to think that he's at any more risk of suicide than anybody else. But I don't have to worry about that because I know, I don't have to make any predictions. He's having a terrible time. It's terrible to be him. It is just awful to be like that. To be constantly thinking that you might be killed by anybody. That is a terrible, terrible way to be.
Kath, let's pick up on that. There is a high level of suffering for a percentage of people with mental illnesses, where they perceive things in a frightening way and their experience of life is torment while they're heavily symptomatic. Does that legitimise some level of intrusion to help?
In theory, what I said was that I think you can, even if you can justify something, there are costs, and what I'm interested in is those costs being counted.
Yep.
So I guess I'd maybe reframe where what I'd say or to that kind of, I guess that kind of broad topic around risk. And I certainly think that you know, the idea of support, if we can focus more on support, I guess to pick up on a practice level what Bernadette was saying on a kind of more meta level, I would say that if we can focus on support and how we give support and use whatever we have at our disposal, whether it's the convention or whatever, to actually give people the support that they want and to find out what their values and preferences actually are, then I think that would go some way again to mitigating against what people are experiencing. I can't speak to someone who, and there are some service. I know there are people who have the most awful, living with the most awful kind of beliefs and experiences. And I sometimes I wonder whether, you know, I'm just throwing this out there. It's out there in the literature, but I know of countries in the US, states in the US where, you know, you can detain people but not treat them.
Yes.
So I think it's worth having those sort of thoughts and conversations which we haven't in Australia as well.
Eleanor, what about those people who we can predict with some confidence will become really unwell and will become very distressed and unable to care for themselves very well if they're not the subject of compulsory treatment? Is there any justification in any circumstances for intervening to provide them with treatment they don't want?
The first issue, I guess, is sort of been highlighted is, you know, how can we be certain that is going to occur?
What about if it's happened
Assuming
3 or 4
that
or 5 times before?
something that's happened, then if the person at that point is in a state where they're not yet at that point, but they're saying it's something that's predicted to occur,
Yes.
then drawing back on, you know, the introduction about working with people and so on is really what should be occurring, is providing the supports at that stage where the person is.
Yes.
You know, what's meaningful in their life, what would they like to see, what is that a situation that they would find distressing, anticipating that might come up, what would they want to do to avoid that situation occurring, rather than, as unfortunately currently happens, services, due to resource reasons or other factors, sit back and wait until a crisis occurs, and then there's no option left but to force treatment at supports and alternatives that a stakeholder person might want to engage and see benefit in that.
Okay. Bernadette, accepting that collaborative involvement, working with people, talking through things, trying to secure agreement, being tolerant and respectful is by far the better kind of dynamic. Is there any situation where it's appropriate to intervene and enforce unwanted treatment? Ever?
Look, I think you can justify anything, really.
Can you justify it?
Can I personally justify it? My position is that at present there will be circumstances because there are no alternatives. And it comes back to what Eleanor said, that the least restrictive alternative sometimes just doesn't exist. So I'd much rather us look towards, well, what can we do to ensure that there are less restrictive alternatives in place, rather than keep coming back to, is it justified? Let's just fiddle with the legislation. Let's try and, do little bits and pieces around the edges, rather than saying, well, is there, as a society, something more we can do to provide supports to look at the positive aspects, so that people don't get to that state of distress. I'd much rather us look at things that way, rather than keep coming back to, well, there will be situations and therefore that just justifies what we have at present.
Okay.
Can I just add, just as part of that, what I would really like to see is whether they're called user-led interventions, but things like voice hearing approaches and stuff that we know.
What do you mean by that?
So a voice hearing approach is a different way of working with people who hear voices, for example, who would have been languages having schizophrenia, where strategies around how to cope with those voices and how to develop relationships with those voices, actually get to know them, are shared in a group and it's facilitated. So it's it's an alternative approach. There's a number of alternative approaches kind of out there that have sprung up that I think form part of those.
Open dialogue.
Yeah, an open dialogue. That's right. And intentional peer support. Yeah, so things that we know work.
Finland diminished schizophrenia by 90% over 25 years by using non-psychotropic drugs, and the bogus scam psychiatric industry is a $28 billion rort on the budget, and that's what's stopping these changes. Follow the money. I took this Supreme Court case for Garth Daniels right across VCAT, right across Troy Barty in the Mental Health Tribunal, right up the Supreme Court. It's absolutely riddled with right up to the judges, riddled with payback, and they're all on the payroll. Follow the money. It's a $28 billion scam industry.
Okay, so there are a lot of vested interests, aren't there? And the status quo is hard to shift because we're accustomed to it. It almost becomes acceptable because it's there. What do you think? What are the things we can do to reduce or perhaps even eliminate mandated treatment for people with psychiatric illnesses? What are your thoughts?
Don't enslave people as human laboratory specimens anymore. I can tell you that stuff was so painful. 14 years of that. And it's for a little conspiracy theory of, thinking about mobile phones. That's not going to do permanent damage to a person's body. They're just going to think about it for a while, and if they get to the right group where they can talk about it, then they'll work it out. But what you guys do, you hold people down, you stick your pricks in, you undress people. It's disgusting what you do. I don't know how you can sit here talking, can we have this, can we have... We need human rights. We don't want to be enslaved anymore. You make money out of enslaving all these people. 5,700 people apply to tribunals that are absolute farce.
Okay.
We don't win these things. They're not even transcripts of these tribunals. We just don't get. And all these people applying, saying no and meaning it, and then the people who just go along with things and don't really want it, but in a quiet, closed little group, they'll say, "Oh, it was horrible, the ECT and the horrible medication, but I can't do anything else." They're not the people fighting in tribunals, but you have 5,700 people fighting in Victoria every year to stop it, and pretty much all of those end up being forcefully treated anyway, sometimes for the rest of their life. Indefinite torture, 24/7 indefinite torture. And you make money out of this slavery by your research studies and all that sort of stuff. So it's just not on. It's got to stop.
Thank you. Let's see if anybody else has a perspective they'd like to share. Yeah.
I come from more of a science background than a legal background. A lot of the talk tonight's been about mental illness, but I was wondering what are your views on the recent changes in vaccination policy? Like obviously vaccination doesn't, it's got effects on not just the person being vaccinated, but also the elderly and the young who are affected by herd immunity in the community. But we're shifting more towards a mandated medical treatment and taking away welfare payments. So I was wondering, do you believe that this is the way to go, or is there another way around this?
Okay, well, we'll get a quick thought on that. Chris, I might dob you in for that one, because there are tough public health considerations about that sort of issue, aren't there?
Yeah, look, it's not an area of expertise of mine, but I know people who are experts. And their view, and I'm inclined toward this view, is that it's not a great idea. I think the people that I talk to say, look, it's much better to try and convince people, educate people. People will, generally speaking, people will vaccinate their kids because actually it's really sensible. You really should vaccinate your kids. But some people won't. Some people will will object to that, but it's a very small percentage of the population that conscientiously object, and frankly they don't matter because you don't need 100% for herd immunity. You only need, it varies from disease to disease, but they don't matter. I mean, fine, that's fine. They don't have to vaccinate their kids. Sure, they've got a free ride. Oh well, that's just the way it is. A much more important thing, apparently, with people not vaccinating their kids is it's really difficult to vaccinate your kid, particularly once you've got more than one kid, because you've got to go to the doctor and it's a hassle and you've got to remember to do it, and so it's much more important to. It's the same sort of equivalent as you're talking about. Actually, forget about forcing people to do it. Change the environment so people make it easier for people to do it. I'm pretty sure that's. Yeah, as I say, it's not my field, but I think that's the way that people talk about it. Makes sense to me.
Can I just make a comment about that? I'd just like to highlight that people who don't vaccinate their children, and I don't want to start the whole debate. Many do it.
It's another night, that one.
Many do it consciously. It's not laziness, and it's not.
They make considered decisions.
And it's not lack of intelligence or knowledge.
No. Some people definitely do. It's just that not many people do.
So I just wanted to say.
Sure.
But I agree with the environmental thing. Create a better environment for people to do it.
John Chestnut, Office of Public Advocate, thanks to all the panellists for your presentation. Going back to Chris's beginning, we were talking kind of in one breath about controversial matters such as compulsory psychiatric treatment, perhaps other forms of compulsory treatment via civil detention. In addition to less problematic medical treatment, someone, for instance, who's unconscious in hospital, where the decision would be made by someone appointed by the person by a tribunal, or indeed according to a statutory hierarchy. I'm just interested in the panellists' views about whether should we generalise our medical treatment laws to include psychiatric treatment. The comeback often is that the compulsory provisions enable or ensure some degree of public safety, which can't be ensured in other scenarios. But do we need a mental health act?
Can we start with you, Emma?
I think with our current model of mental health act, where you have psychiatrists making decisions about the specific treatments that will be administered to the person even once they're on the order, we're necessarily coming from the medical training and medical model and typically have known the person in a very short period of time. There are so many inherent problems with reaching a human rights compatible decision and a rights respecting decision through that model, and I think would have a far more compatible approach if even if we were to accept that there can be compulsory treatment, if the person at least can choose who would make that decision for them, if it can be a trusted person who isn't necessarily from that medical model, who can gather the information and make that decision on behalf of the person. If a decision has rather than it being the doctor who is prescribing the treatment and who clearly has already formed the view that that treatment is necessary. Whether that means we get rid of the entire Mental Health Act is a broad question.
Do we throw it all out, Bernadette? Do we have to get rid of it and start again?
In the McSherryist world,
Oh, no.
we would not need mental health legislation.
No legislation? Everybody will be happy? It's all going to be good?
It's discriminatory. We don't have a Diabetes Act. We don't have a Cancer Act. We don't have an Epilepsy Act.
I think we do have a Cancer Act.
We wouldn't need it. However, we don't live in a McSherryist world. So unfortunately at present, because we don't have an alternative, we are stuck with it. And I can't imagine any government in Australia, unfortunately, wanting to change things. So we are stuck with the current system, which is why I keep trying to find a way around this so that it does become a last resort, that it's not seen as, well, persons in distress, therefore compulsory treatment. It's much more about, well, can we get beyond this so it is a last resort, and then we have a luxurious world and we'll all be happy.
Well, that's almost a place to stop, but let's not quite yet. Any other thoughts or questions? Yes, one and then two.
Linda Steele from University of Wollongong. Thank you to all the panellists. I just wanted to pick up on a point that Kath has made, and also one of the people from the floor, about we're talking about reforming laws and recognising violence and trauma and stress caused by those laws. Do you think that part of that is something that PWD and WWDA, Women with Disability Australia, have talked about not only reforming and changing, but recognising those past injustices and kind of taking a transitional justice approach where part of that being kind of public recognition of past wrongs and part of that might be a public apology or some kind of not only moving forward but naming and recognising the wrongs that have been done through law and medicine in the past, even if they were lawful or okay at the time. Do you think that is relevant at all?
Can we go to you, Kath? Because you've drawn our attention very powerfully to the pain that can be caused by inappropriate, or maybe any infliction
For me, it's
of
any,
coercion.
It's,
What can be done to repair past injustices?
bodily integrity at that point, but it's also against autonomy. So I mean, for me, these are the ethical kind of concerns.
What can we do though to recognise and acknowledge
Well, for me,
what's been done wrong?
whenever you've got a Mental Health Act, that's what I'm saying. It's continuing. There's
Okay.
no difference. So I don't see how we're talking about the past. For me,
The past is the present.
yeah. So until we live in a bit McSherry world, which I want to live in,
I think we'll all have to vote for the McSherry world, won't we?
to live in a parallel universe.
But LSD and the insulin shock, that hasn't got an apology yet.
No, that's true.
Yeah, as to whether you might want to, do it for some
Yeah.
things that have already happened. Yeah.
Just don't do it like this. The College of Psychiatry did it. That's a lesson in how not to make an apology.
What did they do wrong?
They
Tell everyone.
did an apology for past wrongs. So
They did,
the
yes.
college recently published an
Yes.
apology for past wrongs. But honestly, if you want a lesson in how not to make an apology, read that document.
Okay, thank you.
Can I
We will. Hold on just a second, if you would. Yes.
Thanks so much for the discussion. It's been really interesting, and I think we'd all want to live in a McSherry's world. I'm neither a doctor or a lawyer, so excuse my lack of
You're all
articulation.
more welcome then.
Thank you. I just want to ask the panel, or maybe, just explore the situation where you have someone with a mental illness which involves, let's say, a delusional disorder of some type, where they do not have any capacity to understand that what's happening to them is, it's something that's in their mind, and they're not in a capacity to understand that the treatment might help them. That's one point. And my second point is where there's a bit of a tension, as I see it, between their human rights to refuse treatment and their rights to maintain their close personal relationships, their standard of living and their ability to work, their friends, and even the home they live in, and their right to enjoy the highest attainable health that they can reach. And there's a bit of a tension there in my mind between their ability to refuse treatment and the loss of the rest
The
of their human
consequences.
rights
Yes.
as a result of that. You know, I'd just be interested to
Good
know
question.
the panel's comments on that. Thank you.
Panel members.
Sure. No. Well, I think that sort of spells things out very clearly. There is no doubt that a lot of people with serious mental illness suffer enormously. That is just the case. There is no doubt that some treatments for mental illness can ameliorate that, and that is not to deny that some treatments for mental illness don't also have very significant side effects. When somebody can make their own decisions, it's easy. They can make their own decisions. So the idea that somebody, and this happens, and this is bad, that somebody's now fine, but the doctor says, well, you're fine now, but you know, if you don't keep on taking your medication, you know, you'll get crook again. And the person goes, well, yeah, I know, possibly you say that, perhaps not, but I really don't like the medication, it's making me fat. And the doctor says, well, you're taking it anyway. I mean, that's appalling, that's just awful.
And widespread.
And widespread.
It's criminal.
But that is not to say that somebody who's not in that position, who really is convinced of their delusional disorder and it's destroying their life, and who of course doesn't want to take medication because there's no point in taking medication if, I don't know, the CIA is after you, or if you really do have a terribly shaped nose or whatever. It doesn't seem right to let that person to continue to suffer either because they can't work out the benefits and the harms. It just that doesn't seem to be the right thing to do.
The essential tension. Any other comments from members of the panel?
If someone does have a delusion, a fixed delusion, whether or not you would consider forcing treatment will depend on the nature of that belief and the consequences that might flow from it. Is the person acting on it in a way that's going to be so detrimental to them or other people that you might consider treatment? If it's something that is a belief that other people might not agree with and consider false, it doesn't necessarily warrant intervention or compulsory treatment.
Yes, completely. And for example, plenty of people who hear voices which they're not fussed by. In fact, some of my patients like their voices. I mean, just why on earth would anyone want to take that away? I mean, that doesn't make any sense. But yes, but you know, for all those people, there are plenty more people who it is destroying their life.
Any last comments? All right, I'm going to, just a quick one if you would. I'm going to make you quick because it's important we keep roughly to time.
A McSherry World question.
We can't refuse that question.
You made the remark that the CRPD committee has asked Australia, almost demanded Australia to do this. They haven't. Australia ratified the treaty. Australia said, we will do this. And it goes without saying, the entire treaty. And on the 13th of September 2013, Theresa de Jenner in the United Nations asked, are there any reservations in Australia? And the Attorney General got up and said, no reservations. It will be adopted. That's how you get to McSherry World, because it is law. And the abuse against Garth Daniels and thousands of others, I walk amongst the walking dead, who can be talked out of their misery by love. Love is missing in this money-driven system. But the way you can get to the McSherry World is actually force all Australian statutes to fall in line immediately and comply with the CRPD, which they should have already. You can't wait 20 years for Australian law to catch up with international human rights law.
Yes,
Thank you.
Australia, unfortunately, when it did ratify the convention, made a declaration, and that's what it's fallen back on. The declaration says we interpret the convention to allow for substituted decision making, and so that's their kind of get out of jail free card.
They were challenged on that. And
I know, exactly, and it's all
the
been...
Attorney General said without reservation.
Yes.
I know.
Well, it's not wriggle room that they've given themselves. It's an incredible amount of latitude, isn't it? I'm going to draw things to a close because we promised that it would take a certain amount of time. I've been given a book by Bernadette and some other bloke to award to the best question of the night, and I'm going to give that to the lady in the back row in blue. Thank you everyone for coming. Thank you for engaging. We've heard some important things, and hearing about pain and hearing about strong views really matter. And we've heard about other options: love, communication, tolerance, embracing difference, finding other ways. Perhaps those are all roads to the McSherry world. But thank you so much for being here and for participating, for coming tonight. We hope this is the first of many such sessions. Don't go. I think Kate, who's done so much work to bring us all together and to organise tonight, wants also to say thank you and good night to you.
Thank you, Ian, and thank you to all of our panellists. I'll just say a very quick few words to finish up. So my name is Dr. Kate Sear, and I'm a senior lecturer in the law faculty at Monash. I just wanted to say a little bit about this event and to thank a couple of people. So tonight's event is actually a springboard for a two-day workshop that some of my colleagues, some of them who are here up on the panel and others in the room tonight, are holding over the next couple of days. Unfortunately, we can't have you all along again to that, although we'd love to, because this is obviously a conversation that could go on. But if you're interested in following our discussion, we will again tweet. So the hashtag is ASSA16. The reason we use that hashtag is because that event and tonight's event has been supported by the Academy of Social Sciences Australia. So I'd like to thank them for their support. Also the Castan Centre and Bronwyn Naylor for her support, everyone at Castan who's assisted us. Those from the Monash faculty team, especially Kate Daly up the back who's taking photos and who is really largely responsible for pulling all of this together tonight. And my colleagues, Dr. Claire Spivakovsky and Dr. Adrian Carter, who've helped as well. Thank you all very much for coming along. Do follow us on Twitter if you're on Twitter. And we hope, yes, very much to have an event like this again. I want to thank Ian especially for facilitating the panel and for drawing everything together for us and each of our panellists. And we've got a little gift to thank you very much for your time. So thank you, everyone.